Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. Our first case for the day is the public reprimand of Judge Timothy Shea. Judge Shea, please come forward. Judge Shea, we have ordered you here today so that we may fulfill the duty we have under the Florida Constitution to discipline judges for conduct unbecoming a member of the judiciary. This is a sad day for you and for us. Most importantly, the need to deliver a public reprimand makes this a sad day for the entire judiciary. The unbecoming conduct that necessitates your public reprimand today is outlined in the opinion this court issued in March. I will address your behavior in greater detail in a moment. First, it's appropriate to underline the grave seriousness of judicial misconduct and the vital importance of this court's constitutional duty to discipline judges when they fall short of the standards outlined in the Florida Code of Judicial Conduct. The code clearly describes the link between judicial conduct and public confidence in the judiciary. As Canon 1 of the code explains, a judge should participate in establishing, maintaining, and enforcing high standards of conduct, and shall personally observe those standards so that the integrity and independence of the judiciary may be preserved. More specifically, Canon 3B4 of the Code of Judicial Conduct requires judges at all times to be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, and others with whom the judge deals in an official capacity. Judge Shea, you have stipulated that on 4 instances from 2007 to 2010, your behavior fell short of the conduct required of judges. First, upon seeing a prosecutor in your courtroom shake her head, you got up, walked behind her, and screamed loudly at her for what you had perceived to be disrespect. Second, you made disparaging and disrespectful comments as a prosecutor was making a legal argument. Third, you sentenced a defendant without his attorney present and over his objection, and then spoke rudely to the defendant's father. And fourth, you angrily reprimanded a prosecutor in open court when you misunderstood the status of a case. You then ordered him into the jury room and continued to berate him before realizing your mistake and apologizing. As noted in the stipulation you entered into with the Judicial Qualifications Commission, these repeated actions constitute conduct unbecoming a judicial officer and lack the dignity appropriate to judicial office, with the effect of bringing the judiciary into disrepute. We agree with that. Judge Shea, as we noted in our March opinion, your behavior did not meet the high standard of conduct expected of Florida judges. Judicial misconduct does more than damage the credibility of the individual judge who is at fault. As this court has explained in an earlier opinion, as well as the March opinion dealing with your case, judicial misconduct strikes at the very roots of an effective judiciary, where those who are served by the courts will not have confidence in and respect for the court's judgments if judges engage in this egregious conduct. In your stipulation with the Judicial Qualifications Commission, you apologize for your misconduct and realize that you alone are responsible for the intemperance, disrespect you exhibited. It was important to the commission and is important also to this court that you acknowledge your wrongdoing and that you voluntarily took steps to stop your inappropriate behavior. You sought professional treatment and counseling for your temper, and you turned to experienced and respected judges in your circuit for advice and counsel. I must emphasize that absent the steps you have taken to reform, this court would be sanctioning you more severely. I also advise you to consult the lengthy body of case law issued by this court in dealing with cases of judicial misconduct. You will find that this court has viewed any further violations by a judge very harshly indeed. Judge Shea, the Supreme Court of Florida hereby publicly reprimands you for your misconduct. You're free to leave.
Thank you.
Next case on our docket for the day is McKenzie versus State of Florida.
May it please the court, James Driscoll, along with David Hendry, on behalf of Norman McKenzie from CCRC Middle. And there are a lot of issues in this case, but it really comes down to whether this court is going to allow the state of Florida to carry out a sentence of death when there's all this mitigation in this case that has never been considered by any court or any sentencer. And that shouldn't have happened, and we ask that Mr. McKenzie be granted relief.
Is there a,
I'm struggling to find an issue here that is not a direct appeal issue, and that I just don't understand what these issues have, how they can be raised at this stage of these proceedings.
Well, Your Honor, all of our, I'm sure the state would take a different position, but all of our issues, they're not procedurally barred. First is, we offered about 7 ways in which Mr. McKenzie should have been able to have an evidentiary hearing and present this mitigation, so for any claim, he could show prejudice.
He was the captain of the ship. He chose what he was going to do. He was determined to be competent to do that. He made his choices, and that's what he's got. There's not, he can't bring a, can he bring a claim of ineffective assistance of counsel against himself?
He has not.
Well, it seems like in a way that's what's, you're not calling it that, but that seems like in effect that's what this is.
Mr. McKenzie was prejudiced by ineffective assistance of counsel that happened before he waived his right to counsel. And that happened when Mr. McKenzie was in jails throughout the state and nobody bothered to come see this man with mental illness, delusions, cocaine dependence, all sorts of trauma in his background. These are the type of folks that capital defense attorneys deal with every day. And to not see him for months or after arraignment or go travel to see him and then go and waive speedy trial, which meant a lot to Mr. McKenzie, and violate his trust, and there was no attorney-client relationship could form, that led Mr. McKenzie to making impulsive, irrational decisions. And he was prejudiced by counsel not doing a very basic act of meeting with Mr. McKenzie right away, right when the case became known.
So are you arguing that the trial court inappropriately allowed him to represent himself? Because it seems to me that the trial judge went through the colloquy that was necessary and found that he could represent himself.
Technically, the technical application of the Ferretta inquiry was upheld by this court. It was what led up to Mr. McKenzie irrationally waiving his right to counsel. What happened before. That is an ineffective assistance of counsel claim, which requires testimony or evidence outside of the record. And we were not given an evidentiary hearing to put that on.
is there case law that addresses this point, that establishes that a defendant who becomes angry with the lawyer assigned, didn't visit on Sunday, or doesn't come the day that the prisoner desires, that is a basis for ineffective assistance when because he gets angry and then discharges counsel and proceeds to represent himself?
Your Honor, I can't point to a case where counsel didn't come on a specific day. This is about counsel not coming at all and leaving a paranoid, delusional man to think on his own, only to arrive in court and find out his right to speedy trial had been waived without ever contacting or ever speaking with me.
If you could go back to my initial question, would help me tremendously, because I see we have a real problem in formulating principles of law. It seems this is becoming a real trend for prisoners to discharge counsel and then go on their way, even after being cautioned by trial judges time and time again. And then after that's all over, then we spend weeks and months litigating on issues that are essentially, as Justice Kennedy said, that would be traditional ineffective assistance claims. And I'm at a loss because, I mean, we're going to throw this system into absolute turmoil is what my concern is. That's why I'm looking for help or guidance on cases.
Your Honor, I think I think you're pointing to an overall issue, and it comes down to, unlike somebody with a possession of cocaine or some third-degree felony, this is a death case, and this is a case where this...
I realize that. You think I don't know that?
...is called on to do extra analysis and determine whether it's proportionality as part of Florida's constitutional...
Fine, I understand that as well, but I'm asking you about the ineffective assistance claims that are being made here.
Well, there's one, that was it, and that led to Mr. McKenzie's waiver, and that waiver shouldn't have happened.
Now, did the trial court follow the appropriate procedures when a defendant doesn't want to put on mitigation?
Yes, that was upheld on direct appeal.
So, I mean, the trial court did, as required, under those circumstances, had
We're
the
not relitigating
appropriate PSI.
The PSI was not appropriate when it was considered...
Well, was it done? You know, now we're going to get into litigating whether we like the PSIs or not.
Your Honor, the PSI was inadequate, and the court said it was doing it pursuant to Muhammad, because this wasn't a case in which Mr. McKenzie was waiving mitigation. This is a case where Mr. McKenzie, after the trust was violated, attempted to put it on himself. And what it comes down to is, it's not as if death is constitutional in every case. It comes down to whether Mr. McKenzie's case is one of the most aggravated and least mitigated. And there is substantial mitigation that wasn't considered by anybody. And that was part 2 of the brief, and it goes in, it's a great detail. There really comes a point when somebody has sufficient mitigation that death is unconstitutional. And we should have been allowed to show that death is not permissible in this case because of Mr. McKenzie's great mitigation.
I'd like to go back to Justice Caney's first question. I'm looking at the direct appeal, and it specifically dealt with the issue that which is the Nelson inquiry, that if incompetency of appointed counsel is assigned as the reason or a reason for discharging assigned counsel, that the trial court has to make a sufficient inquiry of the defendant, and then also, if the trial court finds reasonable cause that that the counsel's not rendering effective assistance of counsel, then the trial judge should appoint substitute counsel. So the courts over the years have refined the process, and we found on direct appeal that it was followed. I would echo what Justice Caney says, which is that what you're saying is you want a second opportunity to show that it was ineffective assistance of counsel that led to Mr. McKenzie's move to represent himself. And I don't see how that is allowed when we have a specific procedure. It was raised on direct appeal, and it was found adversely to your client.
Well,
I mean, do you acknowledge that holding, that is, that Nelson provides for what you're talking about, when a defendant has genuine concerns about the representation, the trial court has a duty to inquire. So that's the first step. Ferretta isn't the first step where there's a complaint. And that was followed here, and the court upheld it. So you're really saying you want another chance to undo this trial by now having an evidentiary hearing. And I think we would have to change the law of Nelson in order to accept your position.
Well, Nelson takes it considers what the parties say and their complaints, and basically Mr. McKenzie, by the time he went to Ferretta, it wasn't there. But it wasn't where? He was trying to represent himself by that time. There was a Nelson hearing, and the court found that they were not incompetent at the time, enough to remove them at that point. But simply because a defendant loses a Nelson hearing doesn't mean that later there can't be ineffective assistance of counsel claims.
Well, where is the case law from this court that establishes that when we've got this procedure for Nelson, and that the defendant elects to represent himself, not say, well, listen, this is the best I have, so I'm going to have this lawyer, and then I'll complain, that there is a chance to raise this again on post-conviction. What case do we have?
Your Honor, I don't believe that anything like that this has happened very much where
It
there's
happens, I mean, it doesn't happen all the time, but we certainly have. We had one yesterday where a defendant elected to represent himself after being repeatedly cautioned. I don't see how we can allow a defendant to make that decision and then come back afterwards and then try again to get a new trial. It would mean, in my view, every defendant would do this, and then we'd have somewhat of a chaotic system. I just don't see that the law either requires it for justice to be done. So is there any other state that allows what you're talking about? The United States Supreme Court allow this to be the procedure?
Your Honor, one of the points we made is that he had counsel, and he was entitled to counsel. While he had counsel, they were ineffective, which led to the waiver.
That's what Nelson's about. That's why the judge inquired and made a finding on the record and what the complaints are, and if there's a reasonable basis. But too often, a defendant has maybe realistic but maybe unrealistic expectations of what the defense counsel should be doing, and that's what may have occurred in this case.
That also when the court made the Nelson decision, that was without knowing the information that we have outside of the record, which we since developed through Dr. Cunningham. The court made a Nelson inquiry in a vacuum and did not know the special needs that or the special challenges that Mr. McKenzie would present to any capital defense attorney. But that's what we call upon in this state for capital defense attorneys to do, and to not see him when he's delusional, when he has trust issues, when he suffered all sorts of traumas, when he's in the...
So you're saying he was not competent to represent himself?
He wasn't competent to represent...
So again, now you want to be able to raise that issue on post-conviction?
No, he doesn't have to be competent to, he has to pass Ferretta to represent himself, but he was not capable of representing himself, if you mean competence in a general sense. And I believe Indiana v. Edwards...
Do you mean competence mentally, or competent to know the rules and regulations of conducting a trial?
I would say he would have passed competency to stand trial. Competency to represent himself, it's not that difficult of a standard. He can answer the questions right. And then competency to represent, to actually do it fairly or do it decent, he just didn't have that.
We would have to basically do away with people having the ability to represent themselves in murder cases. Then.
Well, you could do that. I mean...
Or else we have 2 trials every time. One I represent myself, I lose, then I...
Well, I mean, Indiana versus Edwards maybe changed the landscape here, but I don't think we can just entirely say in a capital case that the defendant's never going to have the right to represent himself. We couldn't say that, could we?
Your Honor, you could say there needed to be at least an evaluation so we know who this person is before we let them loose on a jury. You could say a lot of things, and then you could say when there's this level of mitigation that we really need to consider that before we allow the state to execute somebody. It needs
Well, we
to
have
be
that now
considered.
in a number of cases, even when we have, wonderful counsel. We don't have a full record of it, but a counsel wants to put on mitigation, and a defendant prohibits counsel from using certain things. And then later on, a new lawyer picks it up, and then all of a sudden the defendant wants to have a new trial on all that mitigation that could have been presented. And does our law allow that?
Not necessarily. It depends on whether counsel was properly advising the client, engaging with the client. If you look at
And so the basic answer is no, we don't allow that because it's been precluded by the defendant's actions. And that's really where this comes back to.
we're not in an instance here where Mr. McKenzie, what he tried to present, what you could see in the shadows of his presentation, what you could see is he wanted to present his traumatic background, his cocaine dependence, his all of that. It wasn't anything out of the ordinary. Counsel just had to have not violated his trust.
Did the trial court preclude this defendant from putting any evidence on that the defendant wanted to put on properly?
It wasn't as if, in some ways, Mr. McKenzie, by rules of evidence, was precluded.
Well, I mean, that's, so you're going to say now the rules of evidence don't apply.
And you're also looking at a case, too, where that court should have seen the videotapes, which I supplemented the record with, that show Mr. McKenzie in that state. And under Mohammed, exercised the discretion to have Mr. McKenzie evaluated. That didn't even happen in this case. That's the fact that the counsel issue is one thing, but there's also instances where the state went and spoke with Mr. McKenzie and told him that he couldn't put on evidence about what he said in his first confession. There's all sorts of other reasons why his mitigation should have been heard.
Well, now, are you saying that once a defendant undertakes self-representation, that the prosecutor in the case cannot talk with that person who's representing themselves?
They can. I couldn't find a rule where it said they couldn't, but
That's the problem. I mean,
the practice is it shouldn't have happened. It should have been with a court reporter so that we wouldn't have these
is
arguments.
there a case that says that?
No, Your Honor, I can't point to one.
You're carving new ground today is what you're trying to do. I mean, I understand that, and then lawyers, that's what we get paid to do. I understand that.
I realize some of this is different and so forth, but what I'm really trying to do is have at least somebody consider a mentally ill, delusional man's mitigation, and let it be considered. That could have happened through an evaluation at trial. There could have been just a little bit more that would have opened up the gate to all of this very, very compelling mitigation. So I raised it every which way I could. I'll be straight with you.
I understand, and you need to be.
But the bottom line is, Your Honor, this man has deep mitigation, and it was never heard. And we can't have a system in this state where there's that mitigation that's out there, and it's never considered. That's unfair, and it's unconstitutional.
Again, I don't disagree about some of this direct appeal issue about the waiver of mitigation. What you're asking us to do is overturn all of our precedent that allows this, and I don't see how we do that on a post-conviction motion. And so, again, and you're way into your rebuttal, but the concern is what was raised at the beginning, which is...
Your Honor, we're asking this court, there's all sorts of different remedies that could be had, and one would be just to have somebody consider this man's mitigation before he suffers the ultimate penalty, because it is deep and it is profound, and if we don't consider that, there's something wrong with the system. And it broke down, and it was, Mr. McKenzie had his part in it, but this is a delusional, mentally ill man who shouldn't have been making those decisions.
Let me ask you this. He conducted the total guilt phase of the trial himself?
Yes, Your Honor.
Were there any red flags that came up that would alert the judge that this man is no longer competent?
He did not ask any questions, so there should have been,
Well, in his opening, he sort of laid out what happened, didn't he?
Yeah, but that could be consistent with a man who is remorseful, in fact, for what it just didn't understand. Hey, maybe we should just have a penalty phase or different things like that. It wasn't wise decision.
But maybe you should be counseled, and then you wouldn't have a fool.
That's true. But being a fool, it could also mean being greatly mentally ill and not being able to make wise decisions that are free from impulsivity. Mr. McKenzie, he didn't enter it in a vacuum, and the defense counsel could have worked with him, but they needed to go see him initially and say, Mr. McKenzie, We're your defense attorneys. Nice to meet you. We need more time. We need to waive speedy trial, and we're going to work with you and present mitigation and take your input and present it in a way that you're comfortable with. And that's what capital defense attorneys do. And at the initial stages, it didn't happen. I see that my time's up, and
I'll give you another time, 1 minute for rebuttal.
thank you, Your Honor.
May it please the court. My name is Mitch Bishop on behalf of the appellee and the respondent in this case, the state of Florida. The argument that there's this mitigation out there that McKenzie had that wasn't presented and that now makes his sentence unconstitutional is clashing with Mr. McKenzie's right to self-determination and to exercise his own free will. He presented some mitigation about his drug abuse, and then that was all he presented. And if he didn't do a very good job of that because he's not a skilled lawyer, then that's the burden that he took on when he elected to waive his right to counsel.
But if we have do you take issue with the assertion that this is a severely mentally ill individual?
I do, Justice Periente. There is a recurring theme throughout the appellant's argument and pleadings that Mr. McKenzie has this generically described mental illness. I would point out that even in Dr. Cunningham's proffer, or what's in the initial brief of Dr. Cunningham's proffer and claim to all of the various mitigation, Dr. Cunningham talks about the psychotropic effects of Mr. McKenzie's cocaine use and some of the delusional effects of that. But to argue that he was mentally ill, or as they, I think, argue, in the throes of mental delusion, is not accurate, even in taking into context what Dr. Cunningham says. He doesn't pinpoint to a particular mental illness. He doesn't, Dr. Cunningham, in what they have proffered in their initial brief, doesn't even come close to saying he suffers from this mental illness or this mental illness under what would then be the DSM-IV, the operative text at that point in time. He doesn't do that. He does talk about the effects that the drug abuse had on his judgment and reasoning abilities, but that's essentially it. And with regard to the rest of the mitigation that they are proffering, though Dr. Cunningham outlines it in, I think, about 26 different forms of mitigation, that can really all be condensed down to something about drug abuse, a little something about child abuse, and maybe some more of his family background.
Does Dr. Cunningham opine anything concerning Mr. McKenzie's ability to have represented himself?
It does not. And Dr. Cunningham does not say that, he says affirmatively, based off what we have from the appellant, that he's not psychotic or schizophrenic. He makes those statements in what we get from Dr. Cunningham. The defendant was evaluated, and I think it's discussed, and there's a little disagreement between counsel here about who said what about his competency evaluations before trial. I think at one time I said McKenzie, or the defense lawyers said McKenzie was evaluated, when it was actually McKenzie himself saying he had been evaluated before trial.
Evaluated in what context and what setting?
Competency to stand trial.
The trial judge actually appointed experts to evaluate him?
No, Your Honor. What happened was Assistant Public Defender Valerino, who during their period of representation before Ferretta, they had him evaluated, and they discussed that at the onset of the penalty phase, whenever they were actually reappointed for a night, and then the next morning McKenzie comes back and has thought about it and decides he still wants to go forward by himself. So McKenzie said something about that in a colloquy with the court in a pretrial hearing about something to the effect, and I'm paraphrasing, they've got 2 evaluations to show that I'm competent. They can turn those over to you right now, indicating towards his defense attorneys. And then at the penalty phase, defense counsel, Mr. Valerino, says the same thing and says, we've not had him evaluated for mental health mitigation to present that aspect of it, but we have had him evaluated for competency, and then that was essentially it. But as to the other mitigation, McKenzie was adamant that he wanted to present only what he wanted, and he presented at the end. He argued a little bit about his drug abuse. The court was very lenient with him and allowed him to present his bank records to show his financial transactions, that he had been withdrawing large sums of money to purchase drugs, and the court was lenient and allowed him to do that, found drug abuse as mitigation. But
But I think my concern, and it doesn't appear that it's a concern that will be applicable to this case, you're really arguing the direct appeal issue, which is that he wasn't precluded from presenting mitigation and he was competent to waive his right to counsel. What I'm hearing being said today is that was one picture, but that wasn't the real picture. The real picture was this was a seriously mentally ill person who had delusions, who couldn't do this, and that therefore the death penalty isn't reliable because there's a whole other thing out there. What you're giving us is that even though there's some proffers in the record, it's not that situation. I mean, there could be a situation, but this isn't that case. Is that what I'm hearing? That there isn't really a diagnosis of what we would think of as the DSM mental illness that might prevent him from being able to to represent himself. It's sort of the Indiana versus Edwards situation.
Correct, Your Honor. I would agree with that. But again, the idea that he couldn't do this, I think the best we can get from the appellant's argument at this point is, as Justice Perry pointed out, maybe he didn't do a good job. Maybe he didn't know the rules of procedure all that well, and maybe he was presented by the rules of evidence from presenting a certain thing or arguing a certain thing, and that's a burden that he took on whenever he waived his right to counsel, but we don't have that situation where he was incompetent to proceed or suffered from some type of mental illness. And the last thing I'll say about the mitigation is that McKenzie was clear that he didn't want his lawyers investigating mitigation. He was preventing them from doing that or arguing with them over whether they should do that or not. And even in the pre-sentencing investigation, when McKenzie's sisters interviewed, she indicated that he didn't want her going into much of their family background. He didn't want to drag their family through this process as well. And so he has the right to that self-determination, to exercise his free will and do that if he wants to. This court said that as far back as Hamlin in 1988, and I cite that in my brief because it was the one that had the actual quote about him having the right to control his own destiny. But this court, as recently as Boyd in 2005, has said that same thing, where it's allowed the defendant to present what he wants to present, even though there may be other mitigation out there, part of the bigger picture, that he chooses not to present because that's his free will. Let me ask
you this. If lawyers were presented, appointed, and even if it was just for a day,
yes, Your Honor.
Did they have any obligation to present to the court anything that they had found, even though that was a short period of time for them to have found something, but were they obligated to do that?
In the time frame they had, I would say no, Your Honor, because here's how that played out at trial. The verdict came out. The jury was excused. There's some procedural matters going on. The judgment and sentence is handed to the defendant. He takes a moment, and he's allowed by the trial court to take a moment to go out and discuss what he wants to do next with his standby counsel, Valerino, and Mr. Quetty. However, he comes back in.
During the entire process, he had the standby counsel.
He had the original capital qualified public defenders that were appointed to him were his standby counsel through the process. He gets the chance to go out and talk to them. He comes back in and he actually asked to have his lawyers reappointed for the penalty phase. The court says okay, and the lawyers ask they're going to ask for continuance, and they're going to need more time to prepare. They're asking for a couple of months. And the court's going to come back the next morning and handle a few more procedural matters and excuse the jury for that time period. When they had
the court already said that, yes, we're going to give you more time to get this together?
The court hadn't ruled, but the court did. I'm sorry, actually, the court did indicate that they were going to continue this out. And I believe that's in Volume 6 of the direct appeal record. I apologize, I don't have the exact page number, but I remember reading that as soon as last night. The court did say we're going to allow you to continue, and then they came back the next morning. They were going to go through some more procedural matters and excuse the jury, and then McKenzie had changed his mind, and he stood up and they went through another full and complete Feretta inquiry, which this court analyzed in the direct appeal opinion. If there are no further questions,
Let me ask you
yes,
this,
Justice Barry.
He claimed that the didn't come to see. Was he in one at all times?
He was not. He was not, Justice Perry. Mr. McKenzie was wanted in Alachua County as well as Marion County for various armed robberies and armed carjacking that he had committed in the months prior to the murders in this case. He was arrested and indicted in October of 2006, and he was taken out of St. Johns County. He was brought back to St. Johns County in February of 2007 for his initial appearance. At that point, he actually indicated first that he was going to hire a lawyer, but he didn't do that. He filed for indigent status later, and a public defender was appointed. A couple of weeks later, the state indicates it's going to seek the death penalty and files that notice, and then capital qualified public defenders enter their notice of appearance, and then when they try to go visit Mr. McKenzie at the jail, he's been taken out of St. Johns County, and he's either in Alachua or Marion County, and it's not exactly clear which one, but it appears to be kind of a chase to find him, because for the next status conference, the trial court issues a transport order, and it issues it to either Alachua or Marion, and when it goes there, he's not there, he's in the other county. And then when they issue another transport order for a follow-on status conference, again, he's not in that county. Now he's in Department of Corrections because he's serving the sentence on the charges for which he pled to in those two counties. And then they finally find him in Department of Corrections and get him out of the reception center in Lake Butler and bring him over to St. Johns County. And it took several months to make all of that happen.
Well, let me just get clear in my mind. What was the time frame from the time he was arrested on this murder and the time that he expressed his dissatisfaction with his attorneys?
He was arrested on the murder in October of 2006. The time he started in open court in St. Johns County expressing his dissatisfaction with his lawyers was in July of 2007.
So he was arrested, I'm sorry, which?
October of 2006, Your Honor.
October and then July.
Yes, Your Honor.
And his allegation is that they did not come to see him during this entire time, or they only saw him once?
His allegation appears to be that nobody came and saw him they tried to go see him in the St. Johns County detention facility, and he wasn't there. He had been transported out to other counties. And so it appears that the allegation, and I don't want to put words in opposing counsel's mouth, but it appears that the allegation is they didn't get in a car and drive to go see him wherever he may be traveling back and forth between the other jurisdictions. So, if there are no further questions, we would ask that the court affirm the summary denial of post-conviction claims. Thank you, Your Honor.
Just briefly, they didn't even call him before they waived speedy trial. And
They waived speedy trial at what point?
They waived speedy trial, I believe it would have been in March.
Is that the first time the case came up?
The case had come up for arraignment. What
for
had
trial.
happened
I mean,
is,
was that the case, he was arraigned, and the case was then set for trial? Am I correct?
no, eventually.
Yeah.
But what had happened was Mr. McKenzie, the aggravators, some of the aggravators in this case, had other cases. He was arrested on October 5th, which you have the video of that interrogation. He wasn't served with an arrest warrant until February 7th, the day after the police interviewed him again.
My point I'm trying to make is that have you ever heard of a first-degree murder case where the state is seeking death, going to trial the first time that case is called?
Never happened.
So there's always going to be a waiver of speedy trial. So it's not that big a deal.
After advising after meeting your client, or at least speaking to him on the phone, yeah, that's generally the practice, unless there's some reason to go quickly. And that could have been discussed with Mr.
Well,
McKenzie.
he could have demanded speedy trial anytime he wanted, and
he
he would have
did.
gotten it.
He did. I think they said it within very close to the time or whatever. He never filed an expiration. I think it fell within. But there was never any evaluation for mitigation. There was, and this is just spoken about on the record, there was perhaps an evaluation that counsel did as a defensive mechanism to find out whether he was competent, and that was all that was done. It wasn't as if they was.
I thought that's what he said, that there was never an evaluation.
That's I believe correctly what happened. But I just would ask that you please at least consider Dr. Cunningham's evaluation. He points to a lot of there are so many things that happen in this man's life and so many things wrong with him mentally and so forth. It is compelling mitigation. And I also ask that you please view that first interrogation where Mr. McKenzie, you can't help but walk away and think there's a lot of mitigation here, and that was never considered because nobody introduced or brought up the DVDs of his first interrogation at trial or at any time. I see my time's up. Thank you very much.
Thank you for your arguments. Next case is Deparvine versus State of Florida. When you're ready.
May it please the court, I'm David Gemmer. I represent Mr. Deparvine. I'm from Capital Collateral Regional Council, Middle Region in Tampa. This is a case where there are numerous failures of trial counsel which were brought out in the post-conviction hearing and in the brief to the court here, which indicate that things could have and should have been differently done, and if they had been done in that manner, that there would have been an acquittal.
It seems like most of your claims, and there was an evidentiary hearing, are classic situations where the trial court and this court says this was an issue of reasonable trial strategy. And it appears that this lawyer wasn't like, he didn't find a witness. It's that he decided not to use the witness, or are there any of the claims that deal with things that because the lawyer didn't investigate, didn't find critical witnesses or discover something, the investigation was adequate, or is this really what, I know you disagree, but is a classic situation of a lot of 20/20 hindsight about, we're looking at it now, we could have done it differently, and it would have been better for Mr. Deparvine?
Well, I identified in the brief a number of instances where what was originally identified as being a strategic decision was in fact rebutted either by the facts of the case.
Well, but are there any that don't fall into that category, where the lawyer did not know about it and it didn't happen because he made a decision, but there was absence of information? Any claims that fall into that?
Yes, there was absent information in the DaCosta issue. Ms. DaCosta actually saw a second red truck, and Mr. Skye testified, and the court found a memo 14 months prior to the trial where Mr. Skye wrote that he believed that the witness, Ms. DaCosta, would get on the stand and say that she saw the victim's red truck. However, Mr. Deparvine testified that over the time of those 14 months, he had several more discussions with counsel, and in fact, at the time of the evidentiary hearing, the counsel, Mr. Skye, testified that he was convinced by the time of trial that Ms. DaCosta would identify another red truck, that it would not be the victim's red truck, and which undermines his initial strategic decision. That initial strategic decision is what the evidentiary court hung its hat on as being a valid reason. At the time of the discussion, actually 14 months prior, that was memorialized in the memo, Mr. Deparvine testified that he had asked counsel to go back to Ms. DaCosta and show her a more useful picture of the victim's red truck. And at the hearing, Ms. DaCosta looked at the pictures of the victim's red truck that were introduced at trial and testified conclusively that that was not the red truck she saw. Initially, they had shown her a side view of the truck when, in fact, her advice to them, or her facts to them at the time, 14 months prior, were that she saw the truck briefly pulling out rapidly and then followed it for a mile or two down the road. So her view was prolonged.
I'm sorry, you said was DaCosta was called at trial? I thought she wasn't called.
No, she wasn't. She was called at the evidentiary hearing.
Oh, okay.
And so we established through her testimony at the evidentiary hearing
Right, so the issue is that you're saying that he didn't know some fact about DaCosta, that if he had known it, he would have called her? Is that what
Yes.
you're... Okay. And the trial court adequately, but that still comes from, he knows about a witness, he decided why he wasn't going to call that witness, and the trial court found that the additional information really wasn't going to be, I mean, it still wouldn't, she would still not have been a helpful witness for the defense. Isn't that what the trial court found?
I don't believe that was the finding. It might have been a finding of insufficient prejudice to justify a new trial, but there's no finding by the court that I can recall that if Ms. DaCosta had testified at the trial, as she testified at the evidentiary hearing, that the truck she observed was definitely not the victim's truck. There was a tonneau cover on one and not on the other. The design of the rear tailgate was different. And so her testimony would have established the existence of another red truck of the same vintage, color, et cetera, within feet or yards of the Jeep, which was the other vehicle involved in the case.
You raised a lot of issues here, and following up on Justice Pariente's question about the Monday morning quarterbacking, you raised a lot of issues in this case, and one of them, I mean, I'm just going to pick a couple. You claim ineffective assistance of counsel because he did not call Daryl Gibson as an alibi witness. Well, Daryl Gibson gave 3 different statements. Only the last one was even closely exculpatory. Had he called Daryl Gibson, you'd probably be standing here today saying it would have been foolish to call Daryl Gibson because he would have been severely impeached. Then we get into ineffective assistance of counsel for not calling Paul Dombrowski or Nicholas Klein or Bill Jamison's widow about the Rolex watch, and claiming that this Bill Jamison walked around prison with a Rolex watch. Well, the wife testified, Mr. Jamison's wife testified, that he never owned a Rolex watch. So had he called these people, you'd be standing here today telling us, well, foolish to call them because the wife would have testified he never had a Rolex watch. So you see all these things here. Either way, it's a catch-22 for lawyers trying these cases. And you raised a lot of these issues where the same thing can be argued, where lawyers have to make a decision as to what to do in the case. And that decision is now being severely questioned by you.
Well, Ms. DaCosta, it was a decision based on insufficient investigation, prematurely made, and in fact, abrogated in his own mind by the time they went to trial. As far as Jamison,
Did they allow prisoners to walk around prison with Rolex watches on? I mean, that would seem to be.
Mr. Dombrowski and Mr. Klein testified. In fact, Mr. Klein provided a real insight into the nature of the prison where they were all confined, where the watch was transferred and possessed by Mr. Deparvine. And that prison had a lot of drug dealers. They had a policy of allowing jewelry, expensive jewelry, in the prison until a crackdown where I think then they backed it off to $50 watches. But a lot of people were grandfathered in with valuable jewelry. So, and plus you could pass it off as a $50 fake Rolex. So there was an explanation for how he could have come into possession of an expensive gold watch. Mrs. Jamison, the widow, although the prisoners rely on family.
She testified that she had to go and put money in his canteen fund so he can survive in prison.
Exactly.
Now, a guy with a Rolex watch, we think, wouldn't need that kind of money.
Well, if he had a Rolex, if she knew he had a Rolex watch, she'd say, "Give me the watch, because I ain't putting no money in until you give me the watch to sell and put more money in." So he would conceal that from his wife, logically. I deal with a lot of inmates, and you don't want to let people know necessarily. We're getting far afield, I'm sorry. But on the Dombrowski issue, Mr. Dombrowski testified that he knew it was an expensive watch, and then ultimately identified as a gold Rolex from a magazine ad that was not sufficiently followed up by counsel. Mr. Gibson, though, his first statement was at the first review of other people who lived in the apartment building by the police. Mr. Deparvine was not under arrest at the time and wasn't going to be under arrest, although you wouldn't know at the time, but he was not under arrest. Mr. Gibson was not inclined to get involved in it and therefore denied knowledge. When the state went back and spoke to him while he was in the Pinellas County Jail, he said, well, I did see something. I saw Mr. Deparvine go down and speak with the victims, and he had a backpack. And then ultimately, on another interview with the state, and he said, and then later in the evening, I saw him standing outside around dusk at the apartment building, which is completely inconsistent with the state's theory of the case, which is that Mr. Deparvine at that moment at dusk would have been far north in the north part of Pinellas County or over in the Hillsborough County area, area, and therefore it was an absolute alibi. Mr. Skye said, well, he was worried that if Mr. Gibson got on the stand and he said the backpack, that people would infer that that was his kill pack. But if you have an alibi, and there was no evidence that the backpack was a kill pack, it was explained by Mr. Deparvine.
And part of the problem is that gentleman had he had been all over the place in what he told the police. And furthermore, there's a problem with that what he said about when he saw them there around dusk was inconsistent with the testimony of the female victim's mother. Isn't that correct? Or what she was told?
She was told by the victim, the female, the wife, that she was following her husband in the red truck and the man who bought the truck. However, she testified that occurred very early in the conversation. The conversation was initiated while they were in downtown St. Pete off a tower that placed them at the apartment building, and would be consistent with Mrs. Van Dusen telling her mother that she was following them around to the back of the apartment building. I'm following the guy who bought the truck. He paid cash. And that would be therefore consistent with Mr. Deparvine's facts, which he told the police from the start, was that they
I thought they were going somewhere to get the paperwork done. I thought that was part of the conversation. Am I wrong about that?
That was the conversation.
That was in the conversation. I'm not sure that was, I think that was excluded. I have to go back. That was not the one that was excluded. You wrote the dissent, an excellent dissent, by the way. But
that'll get you no votes in this one.
That's specific. That's, they were going to get the paperwork done. That all trends over into that they were following the other red truck because, as Mr. Deparvine testified, that other red truck contained a man who had another SUV that he was planning, that they were interested in perhaps going to go ahead and buy. And so paperwork could have been referring to the SUV that was for sale. So Mr. Gibson, and you say that Mr. Gibson was all over the place. No, Mr. Gibson said, first, I don't want to get involved, basically, essentially. I know nothing. Then he told part of what he observed, and then he added the final fillip, so to speak, the alibi. So it wasn't like totally inconsistent. It was building, okay, more and more information. None of it, except for the denial the first time, I saw nothing. But it was not otherwise inconsistent. Like first I saw Mr. Deparvine over there, and then I saw him over there. It's not like that kind of inconsistency. It's not uncommon, I don't believe, for people to build on their
Totally
facts.
change their story.
To build on their facts, yes. So, and Mr. Skye, of course, testified that the pack would be considered to be a kill pack, when in fact Mr. Deparvine had told him it was the chain and locks that he put on the truck. The police found the chain and locks on the truck because he had done that, and obviously he would have had them in the pack. And of course, regardless of the behavior, the alibi cures any possible negative inferences could have been drawn from anything that Mr. Gibson saw before that point. The on the fingerprint issue, Mr. Skye, and this also goes, Mr. Skye contradicted himself as with the cost issue. On the fingerprint issue, Mr. Skye testified that he wanted to have a mystery print. And at the evidentiary hearing, we showed him the evidence that was presented at trial. One showed the ID card from the other gentleman, the other suspect. And then another piece of evidence was the picture of the ID card with a thumb planted squarely in the middle of the ID card. And at the evidentiary hearing, Mr. Skye said he wasn't sure that he remembered that, But it was introduced in evidence, and in cross-examination, he specifically drew attention to the fact of the thumb.
Is that the print that ended up being the fingerprint or thumbprint of a deputy?
Yes.
So what good would that have done to your client? Some
I'm
deputy
sorry?
what good would that have done to your client? Some deputy
Because
picked
the
up the
mystery
evidence.
prints were the ones that were smudged and smudged over by the deputy's print.
From
There were other
strategy-
unidentified, unusable prints.
But you see,
that
from a
were
strategy
destroyed.
standpoint, I can see a lawyer arguing in closing argument. You know, there was a print, the state didn't develop it, that could have been the killer. There's reasonable doubt.
That's what he said he was going to do, and he didn't do that.
Well, I mean,
He
but that
did
was
not
strategy.
argue that in the close because it was destroyed
Well, that's
by
what
the
he-
introduction of the thumbprint at the trial, in the trial. And he did it himself in the cross-examination. It totally evaporated, diminished, or destroyed his strategy, alleged strategy. All he had to do, and he knew that the deputies had not been compared at the scene. That also feeds into the fact that the two police reports on that ID claimed that the card had not been touched anywhere other than on the edges. And so that would have also brought into question the legitimacy and accuracy of the reports by the investigators.
I still have the basic problem that I asked at the beginning and followed up with the questions, that when we talk about a counsel not performing as necessary under the Sixth Amendment, and we do expect a fairly high level of competency, but we don't expect perfection. And I don't, looking at the totality of this counsel's performance, because that's what we really need to do as you pick each thing, I'm still trying to see where where counsel's performance was such that it meets the Strickland standard for either the first prong, or then, assuming he did these things, as Justice Labarga says, a lot of them could have backfired, and you'd be standing saying you should have done the other things. So is there any case that we have where we've reversed with this kind of a record, as opposed to, a defense lawyer that does nothing, shows up 2 days before the penalty phase, doesn't talk to witnesses? This doesn't seem like that's this case at all.
Well, I'm weak on my case names, but and I'm sure you have some cases. I believe it's Wiggins. Correct me if I'm wrong.
Wiggins
Where
out of the
it
US
says the
Supreme
court, the attorney. I'm sorry, but the attorney has to do enough, and if they haven't done enough, even though they've done something.
That's Wiggins versus out of the United States Supreme
you,
Court,
yeah.
of course, and I agree with that. And you think this meets the Wiggins deficiency, this case meets that standard?
Yes, because he didn't do enough. He didn't follow up with DaCosta, made a premature decision, which he even admits that he had come around on by the time of trial.
I think the problem I always had with these cases, even as a trial judge, is that these lawyers represent these folks, and there's a guilty verdict and a death sentence, and maybe 10 years later, they're called to come into court and testify and explain why they didn't call this witness, or didn't call this witness, or didn't do this and didn't do that. And, by that point in time, they can be made to look quite foolish for not having done something. And it bothers me that lawyers have to go through that, but I understand the reason for it. But in this particular case, this lawyer did more than enough, it seems to me. He made decisions. He could have gone one way or the other on those decisions. In either way he went, you would be standing here saying it was the wrong way. There are strategy decisions that we as lawyers make all the time. And sometimes they work, sometimes they don't work. I don't know what else lawyers can do.
Well, but he shot himself in the foot on the strategy claims that he made, the fingerprint, where, he didn't even argue it in the close because he didn't have a mystery print anymore.
Maybe other things came up that he thought were more important. Things happen.
But he blew his mystery print because they put the evidence in that it wasn't a mystery. You didn't know which deputy, but it certainly wasn't the killer holding the picture for the investigator. And another example would be in the carjacking. He claimed that he did not want to clear up which vehicle was the subject of the carjacking by filing a motion of particulars before trial, because he didn't want to give the state a chance to go back and examine the indictment and discover the bogus claimed that it was insufficient, that it was first-degree murder was not sufficiently alleged because they didn't allege premeditated versus felony murder based on a case from the 1800s. And in fact, in this court, I believe 5 ways showed how that was a completely incorrect assumption, or it's impossible. I mean, the first thing is it cures. You cite the statute and you've cured everything. I saw that the first time I saw it, you know, and you all saw it too, as well as the other reasons, the failure to preserve, et cetera. But so he had a strategy on the carjacking. I don't want to file because they might catch the mistake that I'm really going to hang my hat on. I'm going to get them. But then he went and filed a motion for statement of particulars on other issues later. So he destroyed that strategy. And of course, the state didn't catch it because they didn't need to. There was nothing to catch. And so there's another example of where he claims a strategy, but the strategy is obviously post hoc because he did not carry out that strategy.
You've exhausted your time. I'll give you.
Thank you, Your Honors.
May it please the court, Stephen Ake on behalf of the state of Florida. I think this.
Ray, can I ask you a quick question
Sure.
before you begin? I'm a little confused about the. There were about 5 samples of DNA found on the steering wheel on the Jeep.
Correct, Your Honor. 6, actually.
6?
Yes.
One of the samples contained a mixture of DNA of victim Rick Van Dusen
Right.
and the defendant. Can
Correct.
you explain to me how that came about, what that's about?
There were, as I said, 6 spots of the defendant's blood, one of which contained a mixture. I believe that mixture was at the 4 o'clock position on the steering wheel. Some of the other ones they testified to were like the 11 o'clock position. The defendant had his story as to how his blood got into the Jeep, which was rebutted by other evidence. But the state's theory, obviously, was when he committed this murder that he left it and drove that Jeep. From where he dumped the bodies, he drove the Jeep about 1.2 miles to Artistic Doors and then exited the Jeep at that time, and that his blood got on it at that time with a mixture of the victims. Both victims were killed in the Jeep.
Was that DNA sample containing the mixture a major feature of the state's case?
It was certainly a feature, yes, Your Honor. You know, this was a circumstantial evidence case, and that was the only, you know, really direct evidence tied to the defendant there. It was, you know, astronomical odds, 1 in 22 billion, or actually trillion, 1 in 22 trillion, that it was the defendant's DNA. And then the mixture was like 1 in 570 billion. So it was certainly key evidence to the state's case, yes.
Okay, thank you.
But there was certainly quite a bit more, and I realize this is a very factually intensive case, and it's difficult, especially with so many issues. I think this court's kind of identified that this is a very 20/20 hindsight. They're alleging that a very experienced trial counsel basically, even though he investigated things, that he chose one way to go with it, and they're now second guessing that and saying that that was bad.
Just so we have that picture for, you know, since, just to make sure, what type, lawyer experience plus
Yes, Your
what
Honor.
did the record reveal about the investigation that he conducted or had his investigator conduct?
The lead attorney that testified at the evidentiary hearing was John Skye, who had spent, I don't know the exact number of years at the state attorney's office, where he was felony bureau chief for, I imagine, close to 15 years. And then he went to the PD's office, where he was there for about an equal amount of time, I think 13 years. And he testified that he had done over 20 homicide cases, a very experienced attorney. He also had 3 other attorneys working with him and an investigator from the PD's office, all of which were also experienced attorneys.
So this was through the public defender's
Correct.
office. So this is where then he'd have the resources
Yes.
of not a private attorney.
Right. He had 2 other PDs assisting him, along with a dedicated investigator that worked on this case. And there's an abundance of memos in the state post-conviction record because Mr. Deparvine had a legal degree. So he was
He had a
writing.
what?
He had a legal degree. He graduated law school, the defendant in this case,
Oh,
Deparvine.
that's why he was working in the law library.
Yes, and he had written counsel.
I mean, maybe that's not why, but why he was able
Right.
to help people.
He wrote his trial attorney numerous letters, very detailed, and he wrote back. And a lot of those are in the record that as they were relevant to various claims, one of which was this DaCosta witness where the investigator had gone out and shown her photographs of this truck. And I wanted to point out to this court and to correct some of the things that Mr. Gimmer was saying. On page 33 of my brief, I put forth some quotes from that memo where basically trial counsel is saying, Ms. DaCosta thinks she saw this truck. She can't be correct because according to Deparvine's story, the truck's sitting at his apartment. So he knows that she's wrong on seeing that truck. So he says, well, maybe she saw a second red truck. And Deparvine himself points out that's not really that big of a deal because the fact that she sees another red truck at that time of day just doesn't really, there's no way to tie that up to anything. So that's all in the memo as to why. And he said basically he thought he'd be grasping at straws if he tried to present that to the jury of calling Ms. DaCosta. So,
Did Deparvine want him to call DaCosta?
according to his memo, he talked about it with Deparvine, and he said, and I quote, however, the defendant himself was the first to mention that there was no way to tell and know whether or not that was any particular pickup truck. Now, Deparvine comes in post-conviction and says, oh, yes, I wanted him to call, but at the time, the memo reflects that, no, that wasn't the case.
Well, the judge made credibility findings on this. I mean, again, so what we're really looking at here is that the investigation, there really isn't anything inadequate about the investigation. Every decision that's been pointed out was made after giving it some thought. Maybe some things didn't work out quite like they wanted, but that's really, there would be no perfect case.
Well, Your Honor, I think with the vast majority of these, had he presented those, they would definitely be back here saying how that was ineffective because, for example, those inmate witnesses were terrible witnesses, the Dombrowski and what have you, and they had these incredible stories about the Rolex.
I guess what my point was, and I think it's important to understand, that sometimes we go and we'll say, well, this wasn't, this was deficient, but there was no prejudice, and we look at each thing in a vacuum. Here, even if we look at everything in a vacuum, there's no deficiency. No. But if you look at the complete trial, this defendant received competent
Most definitely, Your Honor.
representation.
Yes, excellent representation from Mr. Skye in this case.
To your knowledge, are prisoners allowed to wear jewelry in prison? I mean, I get this thing about the movies where they hose you down when you come in and take everything you got and put it in an envelope and you get it at the end when you come out. I mean,
I honestly don't know. I do know that the state presented a witness at the time of trial that there's no way he would have had a Rolex in prison at the time, and especially his story of hiding it and burying it underground outside the visitor center or what have you, that would have never happened. They presented testimony at the evidentiary hearing that apparently at this correctional institution that they did allow him to do it up to a certain point in time, and then they instituted a policy against it as to monetary value. That anything.
Might have had a watch.
Yeah,
This was before. I mean, this is obvious. He was in for what? Something else at the time.
Yes, he was in. I think he served about a 13-year sentence on. And basically, it was very much similar to this. He was trying to sell a Harley Davidson that he didn't own, and he was caught with a gun in his backpack by undercover cops, and that's what the sentence was he was serving at that time. So he was serving that, and his testimony at trial was basically he had received this Rolex from this deathly ill prisoner.
And you say at trial, at the evidentiary?
No, at trial, Deparvine testified that as to how he received the Rolex, and he had buried it outside. It was very out there, Your Honor. And
okay, so now we're saying, but that theory was so great, we should have had other people to come in to support this.
And the two inmates didn't even identify the watch. They just said, yeah, he had a watch, and that's all they had to that. So that's why counsel didn't call him, not to mention other factors that they had a bad record, and they were bending over backwards trying to tailor their testimony to help Deparvine. So they were writing him letters about requesting information from trial counsel saying, we really need to know everything about this case so that we can help Mr. Deparvine when we testify about this watch. And Dombrowski.
And the watch was that was to show that he had enough money to buy the truck?
That was his theory, as he sold this Rolex watch when he was released from prison and had those funds available.
He got $7,000 for it.
Right. He put a one-day ad in the newspaper, according to him, and the very first people that came to his apartment bought it.
Two Hispanic guys.
Yes, for $7,000, yes. And the state introduced his bank records, and he had never had more than like $800 in his account.
But they're not criticizing counsel for putting him on to say that. Just saying, well, he should have put on more witnesses to
Right.
have, I don't want to get, it could have happened, but it seems pretty
Right.
crazy that somebody's going to be walking around prison with a Rolex watch, even if they allowed it.
Correct. And so that's the issue on all these. And the same thing with Mr. Gibson, and Mr. Gibson was unavailable. He wasn't going to testify. He had numerous statements, as this court has pointed out, from I know nothing to, much different statement at the end. I think this court is well aware that this is a hindsight type of argument, that the trial judge correctly found that there was no deficient performance or prejudice in this case, and we would ask that this court affirm if there's no further questions. Thank you.
Thank you for your arguments. Rebuttal.
Thank you, Your Honors. On the DNA evidence of the blood, one of the crime scene technicians who did the blood work testified, I believe it was at the evidentiary hearing, might have been a trial, but that it would be impossible to determine whether those two blood spots were placed there simultaneously, or, as Mr. Deparvine testified, on the Sunday prior and then on the Tuesday of the murder by the victim. And so it's impossible to do that. Could have gone either way. This court held that it was a reasonable jury could infer both men were bleeding at the same time, but that doesn't overcome the circumstantial evidence rule that has to eliminate the theory of innocence, which would be that, as Mr. Deparvine testified and tried to tell the police, he had a cut finger from work that was reopened and left small blood spots that, as the technician testified at the evidentiary hearing, were impossible to see unless one got up very close using a flashlight to look for. I'm out of time, and I thank you.
For your arguments. The court will be in recess for 10 minutes.
Supreme Court of Florida is now in session. Please be seated.
Our last case for the day is State of Florida versus Drawdy. Proceed.
This case involves a conviction for sexual battery and a conviction for lewd or lascivious molestation for sexual misconduct occurring during the same criminal episode. The state's allegations at trial were that the defendant pulled the victim, who was his stepdaughter, out of bed and vaginally penetrated her with his penis, and then shortly thereafter, after he began that penetration, that he reached his hands up under her shirt and fondled her breasts with his hands. Those were found to be by the Second District Court of Appeal to be a double jeopardy violation under the...
Well, they have a different, apparently the Second District did not understand the facts to be as you have just recounted them.
That's absolutely correct.
Well, I'm having trouble understanding that because I've read the transcript in which the young, the victim indicated that the defendant put his hand underneath her shirt to touch her breast. Isn't that what it says?
Well, yes and no. There is one word that has become sort of a factual dispute in this proceeding regarding that very specific testimony.
Well, I understand. I think I understand what you're saying, but I don't understand why your answer is yes and no, because she did say that he put his hand under her shirt to touch her breast, didn't
she? Was asked the question by the prosecutor, the way that the transcript reflects it is, did he put his hands under your shirt? And she answers, yes, sir. So what we're asserting is that was just either a misstatement or a typo of some kind, but certainly in the context of the entire trial, inclusive of the prosecutor's opening statements and closing arguments, in which he's very specifically...
I'm not following you. I understand that at some point, after she had said that the defendant put his hand up under her shirt, she was asked the question, did you put your, well, I can't quote it, but the reference changed to you as opposed to he. And then she said yes.
I have the quote, and I'm happy to share that with the court. I'm sorry if I'm being unclear. The prosecutor says, what other parts of your body did he touch? This was directly after she had testified as to the vaginal penetration. He says, what other parts of your body did he touch? She says, my breast. He said, did he touch them over your shirt or under your shirt? She says, under my shirt. I think that's probably what Your Honor is referring to. Yes. And that is a correct interpretation of the record.
I'm concerned because I think these questions are really factually intensive. Did the touching of the breast, did it occur while he was during the vaginal penetration, vaginal intercourse, at the same time?
Yes, they were simultaneous at one point, although the penetration occurred, and then...
But it was the same act. Because you can imagine a situation where he could have touched her breast first, and then later touched and the vaginal penetration takes place. That could be two separate instances, but this could be one instance if he is touching the breast while the vaginal intercourse is taking place.
Well, it would be one criminal episode, regardless of the order of those touchings. But they are distinct acts. They're two separate acts, and that really is the point here. That is where the Second District first went astray, is by failing to recognize that there were, in fact, two acts at issue, according to this record, and that's very clear, again, in the context of...
And there are two acts under what theory? Are there two acts because they passed the Blockberger test? Are there two acts because they're of a separate character and type? Are they two acts because they're a temporal separation? Why are they two acts?
Well, they are two acts because they are two physical acts by definition. I think part of the reason that
I understand they're two physical acts by definition, but I am asking you why they are two acts for purposes of double jeopardy analysis.
But when we're talking about double jeopardy, we're talking about two offenses, which do not necessarily equate to two acts. And that is a problem in double jeopardy analysis. There's so much vocabulary involved that we sometimes confuse the terms. But what we're talking about, if there's a double jeopardy violation, that is offenses. And one act can be more than one offense, as defined.
Are we talking about that here, one act and multiple offenses? That's what, or are you saying, because again, I would think, Judge Altenburn talks about the fact that it would be helpful to get this clarified by the legislature, but a rape is almost invariably going to include the lewd and lascivious offense at the same time. It may be different elements, but it's almost invariably going to do that. There may be the touching of the vaginal area first, and then the penetration. So is the state arguing in this case is the reason for the conflict that we're dealing with one act and whether there can be two offenses, or are we talking about a case that is factually distinct because the breast touching was separate and apart from the sexual battery?
What we're asserting in this case is that it involved two acts which comprised two separate offenses for purposes of double jeopardy. And once we make that determination, then we can then go on to determine whether the acts were distinct. If they are, we do not proceed to Blockberger.
Well, the second DCA takes a position that there can be vaginal intercourse cannot occur physically without touching other parts of the body. So you necessarily have to touch either, according to the second DCA, the buttocks or the breast in order to commit the crime of. And so, I mean, how can you be charged with two different crimes if you can't do one without doing the other?
Well, you can do one without the other. I submit that the Second District was simply wrong when it came to a contrary determination. And the holding there specifically said, because the Second District at least realized that we were dealing with a vaginal penetration and a touching of the breast, so specific to those two body parts, the second DCA said that one cannot commit vaginal penetration without a touching of the breast, and that is just wrong. It just is not correct, and it also does not take into account the various ways that sexual battery can be committed, and also—
Well, what is the conflict issue?
Because the ultimate determination by the second was that lewd or lascivious molestation, or convictions for lewd or lascivious molestation and sexual battery arising during the same criminal episode violate double jeopardy. We have Roberts and we have Murphy who came to the exact opposite conclusion.
But if you had but is the state conceding that the breast touching was part of the rape? I mean, whether it was a necessary part. It didn't happen like sometime before there was breast touching and then the rape occurred with a break. You're agreeing it occurred during the same episode.
That's correct, and that's never been in dispute.
And again, in most cases, I realize we have to decide the legal issue, but the sexual battery here either got 30 years. Normally, it's life. I mean, most of the cases it can be life, and then they're saying. For the sexual, for the lewd and lascivious, it's what the judge gave some probation.
5 years probation consecutive.
I mean, but he could have given for the sexual battery 30 years plus 5 years probation and been within the guidelines, right? I mean, I guess we fight about this. There's a lot of cases about it, but the practical effect of the sort of the overcharging is that it creates these problems for the court trying to figure out, are we talking about the same act, same episode, distinct acts? The easiest thing to do would be to find that lewd and lascivious is a separate crime and that one doesn't subsume the other. So would you agree with that? And then they can charge all they want?
That's correct. And factually, these are different physical acts.
Well, let's just assume, though, the case is like that they're using, again, in the act of penetration, there was touching in the vaginal area. Two crimes?
We submit that it could be. Now, the state is always going to be constrained by what it can prove at trial. So in a real world application, that's very unlikely to happen. It's why the state would not charge multiple counts for each thrust when we're talking about penetration. It doesn't make sense in the real world. But lewd or lascivious, the touching of the breast, and the vaginal penetration, those being two acts and thus two offenses, that does make sense. And that is a workable application when we view it through the prism of acts that are of a separate character and type. And that's really what we're talking about here.
But let me ask you this. The lewd and lascivious molestation statute, you can commit an act of lewd and lascivious molestation by the touching of the breast, the vaginal area, the buttocks, or area around the vaginal area, correct?
That's correct.
You can, under the sexual battery statute, you can commit sexual battery by penetration or union with, which I interpret as contact with the vaginal area, the anus, whatever those things are listed. So both of them, both the the lewd and lascivious molestation and the sexual battery statute, in my mind says that you can commit either one of these acts by the touching of the vaginal area. Is that correct or not?
That's
you
correct.
You can commit sexual battery by touching the vaginal area. You can commit a lewd and lascivious molestation by the touching of the vaginal area.
That's correct.
And so, why isn't one then subsumed into the other?
Well, if that was one act, then we would be going to Blockberger.
When you say if that is one act, what do you mean?
Well, because we have some factual scenarios that involve two or more physical acts, as in this case, the vaginal penetration and the touching of the breast. But then there are also cases where we only have one physical act, and this includes one of our conflict.
Well, let's assume that he first, for whatever reason, does something outside touching of the vaginal area and then decides to do penetration of the vaginal area. Is that two separate acts or is that one act?
Those are two acts. Now, whether they
so
are...
he could be convicted of two sexual batteries for having contact with the vaginal area and then a sexual battery for having had penetration of the vaginal area.
That's correct. But again, the way that this analysis should work, pursuant to Michel, and let me back up a little bit, because Michel involved two different types of penetration, but both under the lewd or lascivious battery statute, which was akin to the sexual battery statute, as we well know. That case really presented a sort of renaissance for this double jeopardy jurisprudence. It makes great sense to consider, before you ever get to Blockberger, to consider whether the acts at issue are distinct from one another, because if they are, there is no double jeopardy violation. That is a very simplified, reasonable, logical, rational, workable analysis that gives effect to the intent of the legislature to impose multiple punishments for various criminal offenses. And that is, at the end of the day, what we're concerned with.
So we can say then that as long as you touch different parts, you never have to get to a Blockberger analysis. That's what you're saying?
Not quite, because you still have to consider, it's not enough to have two or more acts. Of course, that is the beginning step of the analysis. We would start by determining whether there is one or more criminal episodes. Here we know it's one criminal episode. Then we have to ask, how many physical acts are we dealing with? Well, here it's two, okay? Then are those distinct from one another? If we say yes, then we do not get to Blockberger, because we know then...
And they are distinct from one another because
of the quality of the touchings, the being of a separate character and type. This case offers a fairly obvious distinct acts analysis, because he used his hands for one touching, and he touched a different body part in its entirety. The other touching was vaginal penetration with his penis. Those two acts are distinct from one another, and because of that, there is no double jeopardy.
And they're distinct, and by saying they're distinct, are you also saying that one is not integral to the other? I mean, that one is not necessarily done in the course of doing the other act.
That's absolutely correct. That's absolutely correct.
But that's really not to me, that's not a legal analysis, that's a factual analysis, that, I mean, again, if you had a situation where after he vaginally raped her, in the same time frame, he anally raped her, the state could charge 2 acts of rape,
Yes.
sexual battery, so that's not, then again, you don't get into the same elements test.
That's correct. It is a factual analysis, but it's a factual analysis that the Second District skipped entirely. And that's why the Second District came to the wrong conclusion in this case. It didn't give effect to the intent of the legislature for imposition of these sentences because it didn't recognize at the outset that we are dealing with 2 physical acts and 2 physical acts that are distinct from one another. I believe what the Second District did in this case and what courts before it have done that yields faulty determinations of double jeopardy violations is the court considered one episode to be one act. Those 2 things are not the same thing. Now,
I know you're saying that they were 2 acts of separate character and type. So where did that actual language about, I know it's in the Michelle case, that they're about separate character and types, and where is that? Is there anywhere in a statute, or is that our characterization?
It is this court's characterization, and a good one, a sensible one, one supported by common sense. That is not in the statute, but it gives effect to legislative intent.
Which is what?
To impose multiple punishments for multiple criminal offenses as defined by the statutes. Now, some cases are going to involve 2 acts, as did this one. Some cases are going to involve potentially 100 acts, and that may not be a sexual offense case. That may be some other type of combination of criminal offenses as defined by the legislature. But when we fail to do any analysis regarding whether the acts are distinct from one another, and then we go on to Blockberger, we really miss the boat because the legislature certainly, and with regard to sexual offenses, the legislature most certainly recognized that these types of encounters can and very often do involve more than one physical act.
You are in your rebuttal.
Well, then I'll save the remainder of my time for rebuttal. Thank you.
Good morning. My name is Steve Corgoza. I'm the Special Assistant Public Defender for Mr. Drawdy. First, let me clarify the record. It's not really clear on exactly how the touching occurred and when it did touch. When I wrote my initial brief, I was focusing on the temporal aspect of the acts. However, in the oral argument, the issue did come up about they could have been his chest to her breast during the act. It was one act. And I think that's where the second DCA comes in.
Well, but I'm looking at your brief and what you quote from the transcript, which was read earlier. And when the victim is asked what other parts, after she talks about the vaginal penetration, she's asked, what other parts of your body did he touch? The answer, my breasts. Question, and did he touch them over your shirt or under your shirt or something else? Answer, under my shirt. I don't know what's, because to touch her breast under her shirt, he's got to put his hand under her shirt. Isn't that an inescapable conclusion?
I'm sorry, Joe. I believe that there's an issue, the question was asked, did you reach under your breast?
That follows subsequently.
Right.
I understand that.
So,
but that does not take back. Maybe she also reached under there. I don't know. I think that's a misstatement. I think she misunderstood the question. I think if you look at it in context,
Right.
she thought she was being asked again. But whatever that means, that does not take away what she said earlier, that he touched her breast under her shirt.
And I don't dispute that, but if you got to look, I think if you look at the entire questioning in context, now, of course, if it's a misstatement that you reach under, that's one thing. But I think you can also...
Couldn't the jury understand from this?
Well,
couldn't the jury understand from this that he reached under her shirt to touch her breast?
Well, the issue here, though, is a double jeopardy, not that the jury found him guilty of this. And the question, I think, really comes down to...
But, okay, if they can understand that and he reached under her shirt to touch her breast, I don't understand how that's not a distinct... This notion that you can't I mean, this acrobatic stuff, I mean, that's just...
Well, I don't think she's saying that he reached under my shirt to touch her breast. She says she touched my shirt. He touched my breast. Did you reach under your shirt? And she said, yes. So there's an impression one can get is that he's not the one who reached under. She opened her breast, and when they had sex, his chest touched her breast. I think that is possible to infer from there. And that's an issue that came up in oral argument, and I think that's what the second DCA really was focusing on. And I agree with the court. If she's saying, no, he reached under, well, then it's clearly he committed the act, and then the issue comes down to is it separate and distinct from a sexual battery. But that's not what the record really shows.
You're conceding that?
I'm sorry, Judge?
That if he reached under the breast, if he touched her breast, that this case is over?
No, I don't necessarily agree with that, Judge, because...
Well, that's what it sounded like you were saying.
No. I'm saying, I'm saying with Judge Kennedy that the court can look, the court can look at it and say, no, I think it's separate and distinct. But my argument is, what the second DCA's argument is that if you file a bear, one cannot touch the body parts in a sexual battery without touching those body. In a sexual battery, one has...
Wasn't Bear overruled in Roberts? I'm sorry.
Well, I'm sorry, Judge?
The problem is, as Justice Kennedy pointed out now, if you're talking about his body, touching her breast while he's penetrating, that's one thing. But you don't reach under the shirt to do that.
But the question was not did he reach under, it's did you reach under?
No, what was he doing? Did he touch any other part of your body? Yes, sir. What other part of your body? My breast. And did he touch them over your shirt or under your shirt? Under my shirt. So if the shirt is on and he's doing whatever he's doing, how do you reach under it with the rest of your body other than your hand?
Because her next statement is she reached under her dress. So I think when you read that in conjunction, I think that...
Well, it seems like to me you're reading way too much into that. You're saying that statement that if it means something, you're saying that it means that he didn't reach under her shirt. And I don't see how you can infer that from the context here. Well, that seems to be an unreasonable inference about what she had earlier said.
Well, the question, though, Judge, is it double jeopardy? And the second DCA said it is. So,
well, I understand that.
So
that's what's at issue here.
Right. So the issue is really...
They also said you can't have sex without touching somebody's breast or buttocks, didn't they?
I agree.
I mean, again,
you agree with that
you
statement?
Cannot have sex without touching one of these body parts? Is that what the court asked? One cannot have sex without touching a body part?
Without touching buttocks or breast. Didn't they say that?
I think one can have sex without touching a buttocks and breast, okay. But I think one does have to touch a body part listed in 800.04.
I think we'd have universal agreement on that.
Let me just go back to this sort of just understanding the two crimes. If all he had done was to reach under her shirt and touch her breast, he would have been without her consent. Now, was her age at the time?
I'm sorry, just say it again.
What was her age at the time?
15 or 14. Or I'm sorry.
If he had done that prohibited act, he would be guilty of lewd and lascivious conduct. Correct?
Well, I think that's a determination.
Well, he wouldn't be guilty of sexual battery.
All right, he would not be
It's
guilty
a
of
lewd and
sexual.
lascivious act. You're saying there's not a crime to
No,
touch
no,
a 14...
I'm saying, no, great. He would be, if there was no sexual battery, it would definitely be a
And
sexual molestation.
so the issue in any event is, I see this, again, as being factually distinct because he doesn't have to touch her breast in order to penetrate her vagina. So there are two separate acts, even if it's within the same criminal episode. But getting back to the Blockburger case or test and how it's been refined, in any event, it doesn't pass the same elements test. So either way, I don't see how the defendant prevails here.
Is the court referring to because of the issue of intent?
Because of it having different elements, that one doesn't necessarily, is not a necessarily included offense of, like, if they had charged of one being a necessarily included offense of the other.
Right, but when I've seen the comparison of the Blockburger with sexual molestation and sexual battery, usually it's, the issue is in Bear and in Second City, they never compare the issue of intent, where sexual battery does not require intent, but sexual molestation does. And that's the only difference where they're saying, well, see, it's a separate, it's separate in sexual molestation because it requires intent, but it does not require sexual battery. However, I think there is a rational explanation as to why the courts are possibly not looking at that aspect. Now, I mean, I didn't write these opinions, but I can suggest to the court that when we're dealing with a sexual battery, whether intent is not an element, the reality is intent is still there. One cannot commit a sexual battery without intending to commit penetration or union. That's intent. And it's the same aspect in sexual molestation. For example, the statute of molestation says, intentionally touched in a lewd and lascivious manner. So if you took out intent like they did in sexual battery, one still could not touch in a lewd and lascivious manner unless there was intent. So even though intent is not mentioned in sexual battery, it's still there, and it's still in sexual molestation. So I think I can only speculate that's where the courts had looked at. Well, the big issue is, can one touch a body part from a sexual molestation? Well,
if that's the big issue, I mean, I'm just going to go with the Justice Kennedy camp here, which is that putting your hand under a 14-year-old's breast is not necessary in order to commit the sexual battery. And I don't think we need to be experts in the field to understand that. It would be, I mean, if the question was he had put his hands right under her buttocks as he was thrusting into, and they charged lewd and lascivious for the hands, maybe we'd have, for the hand touching of the buttocks, but it's...
the other issue, Judge, is, as Judge Altenburn said, there's these nuances in sexual molestation or sexual conduct cases. And really the question is, what is human nature? How does this really work in the human world?
What he was really saying is this is much ado about nothing in 99% of the cases, because the sexual battery, when you rape a 14-year-old, you were going to get a sentence that could range up to life in prison. So for most part, whether you've committed oral sex first before you penetrate, or you've abused your stepdaughter over several days, it's going to be the same thing. You're going to be in prison for a very long time. So having to worry about the nuances about what gets touched first is really not very productive for jurists to be engaged in here when it makes so little difference. I thought that was the thrust of Judge Altenburn's.
Right. And that's why I would suggest Judge Altenburn's response to how to handle this is basically the same way as the trial judges handle dealing in stolen property and stolen property. You can't be convicted of both. So the court could dismiss one at the end or make a decision.
But that's the same exact act there, isn't it?
It seems to me here, though, that what you're arguing overlooks the fact that Justice Parody was focusing on is that there are two separate physical insults to the victim. There's two separate acts of physical violence against the victim. And sometimes these things get analyzed almost like this is an ordinary kind of sexual episode. This is not. These are acts of violence against a victim. And it seems to me, when you look at it in that context, you understand that that is something that when he put his hands up under her shirt to do what he did, that is a separate act, which is worthy of a separate punishment. Why am I wrong?
Well, I'm not saying you're wrong, Judge, but I think, this was...
You don't think if your understanding of the facts of this is that because of some cryptic answer to a question later, that undoes what she had said earlier about him touching her breast under her shirt. I have trouble with that. If your whole case depends on that, that's problematic.
My position is that, my personal position, for whatever it matters, is that this court has to determine, in the course of, let's say, sexual intercourse or of sexual battery, where are the lines in touching a breast or touching another body part? Is it part of the act, the sexual act, total act? Can you really break it down into segments and say, no, we're going to break this down into this segment, this down into this segment? I mean, where is the reality of the act? Does the reality act really encompass that, or does it not? And I think that's what the court has determined. If the court says, no, even though it can be, we think it's not, well, then that's
But in this case, I think what we're saying is it's not. If it was that he had to hold on to her buttocks in order to rape her, and they were charging that, closer on, come on, what are you doing, state, in charging two separate acts? But, but if there was, 5 minutes before he forced her to commit, have oral sex, and then he had oral sex with her, and then he touched, they could charge separately. Now, realistically, the court's going to, most of the time, run these sentences concurrently, so that's why it just ever come up.
Let's just assume, Judge, that when he's committing the sexual battery, as he's committing the sexual battery, as Judge Kennedy says, he reaches up under her dress and touches her breasts. Is that really a part of the sexual act, or is that separate and distinct?
Well, I think that what we're saying is that it's not necessary in order to commit the sexual battery, so yes, it's a separate act. If, on the other hand, he was in the process of raping her and his chest was against her breast, probably not. I mean, but I don't think that's a hard distinction to make for the purposes of trying to effectuate legislative intent. We're not here giving our own policy statements, right? We're trying to decide what the legislature intended by having two separate statutes, correct?
I agree. And this is an issue that's, I know it's coming up in front of the court with Rafton and Murphy. So, you're going to have, these are tough decisions to make because you're dealing with human nature and a human sex act. that's very personal and intimate relationship.
But it's not a human sex act.
I'm sorry, Judge?
This is not a human sex.
I agree. I agree. I think it's an act of violence. I don't dispute that. But I'm saying when the overall, the picture of it all.
Let me ask you this. Do you agree with the state's position that once you say this is two separate acts, you don't have to deal with Blockberger?
Yeah,
I would think it's clear in my mind that touching of a breast is certainly not the same as penetration of the vagina, and so is that simply enough? Because those two acts occurred, you don't need any analysis of whether, under the statute, little lascivious molestation has any elements that sexual battery does not.
Yeah, Judge, I would generally say yes, but the problem that I see
yes to what?
Yes, if it can be shown that's really two separate distinct acts, I don't think you have to go to Blockberger.
Blockberger analysis.
But I think the issue, and the court has to decide, is that temporal issue. If it's still, is that part of the act? Can you break it down into pieces? Is that realistic
And Michelle, did we go? I don't believe, and maybe you can correct me if I'm wrong, that once we got to the part of a separate character and type, I don't think, was there any discussion of temporal relationship?
No, I think the court, and Michelle got rid of the temporal issue. But that was in sexual batteries. Now we're dealing with a sexual molestation. So where the court
I thought Michelle was about two.
I mean, a lewd lascivious battery.
Lewd and lascivious.
Lewd and lascivious battery, right.
Yeah.
And it specifically said it's lewd and lascivious battery, not molestation. And I think that's what the whole issue is, and that's what the court has to decide. Is it part of the act? Is it not part of the act? How do you break it down? And is it,
It just seems to me, if you can get, without any double jeopardy problems, 2 convictions under the same statute, then why are we here worrying about 2 convictions under different statutes?
Well, I think because we're dealing with a sex offense, and I think like death is different, I suggest to the court sex offenses are different. This is not where, for example, where you have the lewd batteries, where you know specifically that started, it ended. And Block Burker involved 5 separate sales of drugs. Wasn't even contemplating applying sales of drugs to sex offenses. So I suggest when we're dealing with a sex offense, maybe that's different. Maybe it's not. But I mean, an act is an act, and the court has to determine how these acts break down. Okay, thank you very much.
Thank you. Bottle.
May it please the court, there are just a couple points that I want to make. This case really presents this court an excellent opportunity to clarify double jeopardy analysis, and in so doing, to clarify the vernacular of double jeopardy analysis. First, we determine how many episodes there are. If there's only 1 episode, we have to determine the number of physical acts that occurred within that episode. If there are 2 or more, we need to analyze whether they are distinct from one another. If they are distinct from one another, there is no double jeopardy violation.
When you say distinct from one another, you're using it as that separate character or type?
Yes, Justice Quince. Are the acts of a separate character and type, do they have a different quality about them? And
what haven't we said? What about that haven't we already said? I mean, you saying we need to clarify it. It seems to me, reading all of our cases, that's correct.
Well, absolutely, I agree. But yes, why would I not? But the second district, in its opinion, specifically rejected Michelle on the grounds that it applied only to Section 800.
Well, they just had a different view about what touching the breasts have to do with rape. I think it's right. I mean, it appears that way. So I don't know how much farther we need to go about the clarification. But so again, if we decide these are separate character and type, then you don't get to, as was admitted, you don't get to the Blockberger analysis.
That's correct. So if there are no other questions, we would just ask that this honorable court reverse the second district. Thank you very much.
Thank you for your arguments. Court is adjourned.
All rise.